Thank you very much. For those of you who read the Ontario reports, it's probably not necessary for me to introduce our next speaker, Earl Cherniak from London, Ontario. Earl gets as much publicity out of the Ontario reports as any lawyer in Ontario that I know. Earl was called to the bar and graduated from Osgoode Hall in 1960. He was a gold medalist in the Chancellor Van Connet Scholarship. He is now in private practice with Lerner and Associates in London, Ontario, and is a senior partner in litigation, and as I said, has an active practice in all of the courts at all levels in the province of Ontario. He's not only a member of this society, but of the Alberta Bar. He has been a director, vice president, and president of the Advocates Society of Ontario. He is a member of the American Trial Lawyers Association, the Alberta Trial Lawyers Association, and has sat on many committees for the provincial government and this association. He's the author of many articles, instructs in the bar admission course. Earl Cherniak will now speak to you on the designation punitive and aggravated damages. Thank you.
Thank you, Bruce. 2 years ago, I spoke to the similar lecture series on the subject of damages in tort law. And I said that, what am I doing wrong?
You're doing everything right.
And I said that in no area of the law had there been such an explosion of judge-made law within the previous 10 years. The law in that area, the judge-made part of it, is pretty well settled, except for the area that Ted Rachlin talked to you about. But one can't say that about punitive damages. But I venture to predict that the next 10 years will see the judiciary use their power and their willingness to do some social justice by using the award of the punitive damages in a way that was hardly imagined just a few years ago. The research for this lecture and a lot of the drafting was done jointly by an associate of mine, Jerry Morris, who's in the office. We had a lot of fun getting together the material to do this lecture, and the lecture itself will be a good deal more comprehensive than what I'm going to talk about in the 40 minutes or so that I've got to cover the subject today. We hope that the paper will be a useful reference when you have a problem in this area. We found that the law is developing very, very rapidly due to an increased awareness by the profession and the judiciary that such damages are available and a willingness of the bench to award substantial sums of money by way of damages, which makes the pursuit of these damages by lawyers economical. The purpose of this paper is, we hope, to bring some order to the confusion that's crept into the law and to point out some of the anomalies and hopefully to point the way, or at least try to predict where the law might be going in the next 10 years, and to provide a guide to the practitioner wending his way through this very thorny field. The first order of business is to get the terms straight. What do we mean when we talk about punitive and aggravated damages and exemplary damages? Those are the three common terms that are used. Judges, even today, tend to use the terms aggravated, punitive, and exemplary damages as interchangeable when they're talking about what we'll see are very distinct concepts with different considerations which apply to their applicability to a particular case. In the paper, we go to considerable length to demonstrate what that confusion is and what we believe the correct position to be. For the purposes of today, let me outline what we think that the correct position is and the correct terminology is, in which, if accepted by the courts, would at least have everyone talking the same language so that what's being done in the cases can be properly understood. Damages under this heading, aggravated, punitive, and exemplary damages, take two distinct forms. There's a compensatory aspect and there's a pure punishment aspect. The compensatory kind are properly called aggravated damages. They are personal to the plaintiff. They commonly occur when, in addition to an injury suffered by a plaintiff at the hands of some defendant, that plaintiff has been humiliated, outraged, degraded in some way by the defendant's conduct, and therefore can be said to have had his damages aggravated or added to in a way that can be the subject matter of an award. In other words, it's compensatory.
I wonder, is Ken Chalmers in the audience here?
Yes.
Ken, there's an important, urgent, personal matter. If you'd speak to George Collins Williams in the hall.
Thank you.
Right, sorry.
Okay. The theory is of these aggravated compensatory kind of damages is that they're not punishment, but are in addition to the pure compensatory damages to compensate the plaintiff for the insult that he suffered, as well as his actual loss. As we outline in the paper, this whole area is kind of fuzzy because it's hard to understand what these additional damages for the insult are if they're not in some way as well to punish. And there's certainly some writers and judges theorize that in the aggravated compensatory kind of damages, there's a punishment aspect as well. And that's really important when you get cases where there are both kinds of damages present, so that there'll be no duplication in the damages. The second kind of damages, which are properly characterized as punitive or exemplary, and those terms can really be used interchangeably. The second type is punishment pure and simple. They're awarded as punishment without reference to whether the plaintiff suffered from that conduct or not. They're awarded to deter the like-minded from following such conduct, and is punishment to the person who perpetrates the acts that result in the liability. They're not compensatory, and in effect are a true windfall to the plaintiff who brings the action in which they're awarded. Now clearly these two distinct kinds of damages may coexist in the same case, because the act that causes the one may well cause the other, or may well result in the other. And the courts must be careful in assessing the damages not to duplicate the punishment to the extent that they have given vent to their spleen in adding to the compensatory damages by this aggravated award. They may also exist independently and be awarded. Punitive damages may be awarded even when there has been no addition to the plaintiff's compensatory damage occasioned by the conduct. Anyway, through this talk and through the paper, we use the terms aggravated, punitive, and exemplary in the sense that I've just outlined. All cases before Rooks and Barnard, and many of the recent cases as well, must be analyzed to determine what they actually awarded, what kind of damages they actually were, notwithstanding what the judges called them. The cases of Rooks and Barnard in Broom versus Castle was the libel action that Claude Thomson talked about earlier this afternoon, are the watershed cases in the punitive damage area. And when you run into a problem in this area, you really must read those cases. Properly read, they at once ended the confusion in terminology, or should have, if read properly by the judges who decided cases since that time. And on the other hand, ending that confusion in terminology, they created the new confusion and problems by setting out what the law of England was with respect to the categories in which punitive damages could be awarded. The cases themselves go through a very learned analysis of the history of the subject in these cases, and they clearly set out the distinction between the two kinds of damages, aggravated on the one hand and too punitive on the other. Having made that distinction, the House of Lords in Rooks versus Barnard then went on to decide that in England, punitive and exemplary damages could be awarded in only three very restrictive categories. The first was where there was oppressive, arbitrary, or unconstitutional action by government servants. The second was where the defendant's conduct was calculated to make a profit, exceeding the damage caused to the plaintiff. Thirdly, where such damages were authorized by statute, which is a pretty restrictive category all on its own. And that's still the law of England, that punitive damages can be awarded only in those three limited categories. What is often forgotten is that these categories in no way affect the jurisdiction of the court in England or anywhere else to award aggravated damages, that is, the compensatory kind of damages, wherever proved, and which may involve compensation for that improper conduct, even though it has nothing to do with those categories. The categories apply only to these true punitive or exemplary damages. Now, Rooks and Barnard was decided in the mid-1960s. Castle versus Broom came along in the early 1970s. That was the libel action where the defendant knew that they were libeling the plaintiff and decided we're going to make more money than any court will ever award against us in a libel action, so we'll go ahead and print this book. Came to the Court of Appeal in England, and Lord Denning wanted in the worst way to hold them liable for punitive damages, but felt that he was precluded from doing so by the decision of the House of Lords in Rooks versus Barnard, because he felt that the case did not come into any of those three categories. I'm not sure that Lord Denning really felt that, but that's what he said, because what he wanted to do was say that the House of Lords decided Rooks versus Barnard per incuriam, and that's just what he said they did. He said they simply were wrong, and therefore he refused to follow Rooks versus Barnard, because he said the House of Lords would no doubt realize that they were wrong and would change their minds once they read his analysis of why they were wrong. Well, Lord Denning lost that battle because the case went up to the House of Lords, and the House of Lords said in no uncertain terms, in language that's well worth reading in the decision themselves, that the duty of the Court of Appeal, whether it was headed by Lord Denning or anybody else, and it was a unanimous judgment of the Court of Appeal, was to loyally follow what the House of Lords said, and not only could the House of Lords not be wrong, it wasn't wrong. And since 1972, as I say, there's no doubt that the law of England restricts punitive damages to those categories. The House of Lords didn't interfere with the result in Broom versus Castle because they said that the conduct of the defendant in publishing this libel and knowing they were going to make a profit out of it came within a proper interpretation of their second category, where there was a calculated profit to be made so that the plaintiff won based on one of their restricted categories. These decisions restricting the law of punitive damages in England were not well received in the Commonwealth. In Australia, the Supreme Court of Australia refused to follow it, and Australia still had, or maybe still does, but certainly had, since Broom and Castle, the right of appeal to the Privy Council. And the Privy Council, after Broom versus Castle, dealt with an appeal from the Supreme Court of Australia, wherein the Supreme Court of Australia had refused to follow Rooks versus Barnard and Broom versus Castle, saying that it might be the law of England, but it wasn't the common law of Australia. And the Privy Council really had to decide principally the issue as to whether the common law in Australia could be different than the common law of England, and the Privy Council held that it could. So we had the spectacle of the Privy Council, made up of the law lords who make up the House of Lords, deciding the common law of Australia was different than the common law of England. In Canada, the situation, unfortunately, perhaps fortunately for lawyers who do this work, is still unclear. In the paper, we document at some length the difference of judicial opinion in Canada and demonstrate that this issue will eventually have to be resolved by the Supreme Court of Canada. It's clear in Ontario, where our Court of Appeal has held at least twice, a case called Pretu versus Donald Tidy and a case called Guzenko versus La Folie, that the restriction does not apply here. It's a wider common law version, not the restrictive categories. In one of those Ontario cases, which was decided right after Rooks versus Barnard in the mid-1960s, but didn't mention it, the case actually went from the Court of Appeal, and an application for leave was granted to the Supreme Court of Canada, and an application for leave was made to the Supreme Court of Canada, and leave was not granted. And the Supreme Court of Canada dealt with the issue in arbiter in a judgment by Mr. Justice Spence in a case called McElroy. And Mr. Justice Spence said in this arbiter, and it was not only arbiter, he was a dissenting judge in the final result of the case, but Mr. Justice Spence said that in his view, the Rooks and Barnard restrictions did not apply to Canada. So the only judge in the Supreme Court of Canada that's ever mentioned the matter has said it doesn't apply here. There have been appellate decisions in other provinces which have applied the categories of the Rooks versus Barnard case. The Supreme Court of Canada has touched on the matter in two other reasonably recent cases. One was the case of H.L. Weiss versus Omnis in 1975, where that court heard an appeal as to the proper quantum of the punitive damages awarded at trial and increased those damages. But it didn't mention at all, apparently wasn't argued, as to whether such damages could or could not be awarded. It simply assumed that they could be awarded without relying on it. And there's some suggestion on the facts of the case that it would have been a Category 2 case in any event. Chief Justice Laskin said, in part, in that case, the German company, Omnis and Eisen, German companies combined together to obtain the plaintiff's business and its goodwill without paying for it, and succeeded in doing so. So it's a good argument that that's a Category 2 case in any event, and as I say, the Supreme Court of Canada didn't really deal with it. They recently had to deal with a similar issue in the well-known case of Lister versus Dunlop, where there was an illegal seizure which resulted in punitive damages among other kinds. Mr. Justice Rutherford in the lower court awarded, among other damages, punitive damages. And the case finally got to the Supreme Court of Canada, which restored Mr. Justice Rutherford's judgment. And the court, in restoring that judgment and directing an assessment of the punitive damages, and that reference happens to be on this week, as a matter of fact, said this: the facts and circumstances of the receiver's entry into possession with an armed guard and the protracted delay by Dunlop in replying to the demand for the return of the auto parts to Chrysler are a sufficient basis, in my view, for the exercise of the trial judge's discretion to award exemplary damages. The place in the law of Ontario of exemplary damages for wrongful seizure was not argued here, nor does the record reveal any argument being directed below to the right of a trial judge to make such an award in law. Accordingly, the matter is taken no further than to restore that aspect of the trial judgment. So it seems pretty clear that the Supreme Court of Canada considers the question still to be an open one. My own view is, with some trepidation, because usually when I attempt to predict what the Supreme Court of Canada is going to do, I'm wrong, is that ultimately Rooks will be rejected in Canada. The concept of true punitive damages is too deeply ingrained in our law all across the country, to some extent because judges have never really distinguished between these two different kinds of damages, simply given a lump sum award which lumps the compensatory, aggravated, and punitive all in one. what talks about punitive damages, and also the Australian experience and the cases that I've talked about, which referred to the matter in the Supreme Court of Canada, to date will be persuasive. So I think it's safe to say that, that punitive damages in the broad sense and not the restricted category sense will continue to be the law in Canada. Now, we spend some time in the paper on the cases involving intentional torts and negligence. And it's the negligence part that's the most interesting. There's no doubt that both kinds of cases will track, let's put it this way, both kinds of damages can be awarded in the case of intentional torts. And of course, they're the most common ones in which punitive damages have been awarded. Trespass and assault combined with the conduct which can be characterized by the courts as high-handed, vindictive, insolent, malicious, disregarding every principle which actuates the conduct of a gentleman or gentlewoman, contemptuous, wanton, oppressive, flagrant, inexcusable, reprehensible, outrageous, are all words that have been used by courts to characterize these damages, or the kind of conduct that will attract such damages. In the case of intentional torts, the real issue, or the legal issue that's attracted some attention recently, is the question as to whether there has to be an intent directed specifically at the plaintiff, or whether the mere intent to do the act is enough. There's a case in British Columbia called Theodore, which held that such a specific intention was necessary, but subsequent cases have made it clear that so long as there was an intent to do the act with the element of high-handedness or outrageous conduct, that will be enough. The courts will presume that the defendant knew or should have known the consequences of his act, whether or not they were specifically aimed at the plaintiff. Now, this argument is really very relevant to negligence cases. For a long time, it was thought that punitive damages couldn't be awarded in negligence cases because there was no intentional tort. The recent cases have changed all that. In Ontario, it goes back to a case called Denison versus Fawcett, where the Ontario Court of Appeal said really in arbiter, because it was an intentional tort case, that an award for punitive damages could be made in nuisance and negligence cases, as well as deceit. The real issue there was deceit. They held it could be allowed in deceit, and went on to say, and also in negligence and nuisance. This case has been doubted in other cases, but a similar result was reached in the Robitaille case in British Columbia, which I'll talk about in a moment, and a products liability case called Ree Blackyear's estate in Prince Edward Island. The Robitaille case is really the most important case in the negligence area with respect to punitive damages. Robitaille was a hockey player with the Vancouver Canucks. The club, among other things, in the contract they had with him, undertook to provide him with reasonably necessary medical care. In the course of a regular season game, he was injured, although the extent of the injury was not appreciated. And he was, in effect, forced or shamed by pressure from the front office to play, even though he complained of his injury. And he did play, and he suffered an aggravation of that injury, which ruined his career, ended his career. Even after the second injury, until the full extent of it became known, which was some days, he was still subject to this pressure and humiliation on the basis that he just wasn't the kind of fellow that was good for the league because he wouldn't play hurt. The trial judge awarded $400,000 in compensatory damages based on the shortening of his career, and $35,000 in punitive damages, totally apart from the compensatory damages. He really called them punitive and aggravated damages. And that award was upheld by the Court of Appeal in British Columbia. I'd like to read a couple passages from what the trial judge said because they're well worth noting. The trial judge talked about the Theodore case, where there was this question of whether there had to be an intention to direct the conduct right at the plaintiff. And he said, in the Theodore case, there could be no suggestion that the negligence of the defendant was directed against the plaintiff, or that there was any intent to do the act which resulted in the injury. That, of course, is not the case in most actions arising out of personal injury caused by negligence. The plaintiff is entitled to recover if the defendant reasonably should have foreseen that his want of care could cause harm to the plaintiff. Rarely has the defendant shown to have any particular knowledge of the plaintiff or any intent with respect to him. In that respect, this case is quite different. The negligence here consisted of a course of conduct deliberately undertaken and persisted in, which was directed solely against the plaintiff. There was no intention to cause the injury, but there was clearly an intention to do the act which resulted in the injury, and an act intentionally directed against the plaintiff. And the judge went on to say, the circumstances of this case would justify an award of aggravated damages. There was the element of damage to the plaintiff's feelings, to his pride and self-respect. Whenever the end came, the plaintiff could reasonably have expected to retire as an active player with honor and respect. By reason of the defendant's behavior, the end came in circumstances of humiliation and dishonor. He was stigmatized as a misfit and a quitter who would let the side down. The circumstances of this case would justify an award of aggravated damages. There is the element of damage to the plaintiff's feelings, his pride, self-respect. The award which I make can then be considered as being aggravated as well as exemplary damages. In the Court of Appeal, in affirming the judgment, said much the same thing. To employ some of the criteria most often used, the conduct of the defendant can be described as high-handed, arrogant, and as displaying reckless disregard for the rights of the plaintiff. The management and medical team of the defendant convinced themselves that they knew what was best for him, and having done so, pursued their wrong-headed course, oblivious to the obvious fact that if their treatment was wrong, the result could mean disaster for this healthy man. In carrying through their chosen treatment, they showed a callous disregard for his feelings and his well-being. They ignored the dictates of common decency as well as common sense. The negligence of the defendant flowed from and was directly linked with the arrogant and high-handed conduct of the officers and servants of the defendant. And they went on to say the trial judge was justified in awarding both aggravated and exemplary damages. So it's apparent that it's not every negligence case that is going to attract this kind of award, but negligence cases which have that element of high-handedness, arrogant conduct, may well attract such awards. What's going to be very interesting in the negligence cases is the extent to which the courts are prepared to make punitive exemplary damages awards in products liability cases. We deal with the issue of contract, which is the most unsettled area of this law at this point. The problem goes back to the leading case of Addis versus Gramophone, which all of you will remember from your law school days, where the House of Lords refused to award punitive or aggravated damages in a wrongful dismissal action, and laid down that in a contract action, no such damages could be awarded if the case were framed in contract. Seems to indicate that if the plaintiff wanted such damage and the conduct warranted it, the plaintiff could frame the action such as intimidation or something outside the law of the contract. The exceptions to the rule of no such damages in the contract are very limited. There's a few technical ones in the commercial cases. Mr. Justice Judson in the mid-1950s, in a case called Dobson versus Winter in the Supreme Court of Canada, said in obiter that such damages, that is punitive damages, were obviously untenable in contract. No discussion of it. He just said, obviously, no such damages in a contract case. Even in the Robitaille case that I just talked about, the Court of Appeal seemed to assume that there was a limitation on the awarding of punitive damages in a contract action. Now, the Addison Gramophone principle has been whittled away at, and in my view is about to topple. One of the reasons that it may be applicable or not be applicable to to this kind of action is because there's been a failure to distinguish between aggravated and punitive damages. Whatever the correct position is in contract cases dealing with punitive damages, the position of aggravated damages, which are of a compensatory nature, must be quite different. In contract, we're familiar with the holiday cases, of which Jarvis and Swan Tours in England is perhaps the leading case, where general damages for inconvenience, upset, mental distress, where holiday is not as represented, have been awarded in pure breach of contract actions. In our own courts, there have been several instances of this kind of action being successful. Similarly, recently in Ontario, there have been a number of cases where mental distress, damages for mental distress have been awarded in wrongful dismissal actions. Pilon versus Peugeot is one case. Brown versus Waterloo Police Commission, recently decided by Mr. Justice Linden, is another. There's a difference of judicial opinion in Canada as to whether those kind of damages can be allowed in wrongful dismissal actions. A recent Western case dismissed such an act, or dismissed that aspect of an action on the basis that the question of mental distress was not a part of the employment contract. Since it wasn't part of the employment contract, you couldn't make an award for damages for the mental distress caused upon breach. That reasoning, in my view, is very suspect and wrong, since the issue in these cases, in the employment cases, is not what was a part of the employment contract, but rather what were the reasonably foreseeable consequences of a breach of the employment contract. And if mental distress was a reasonably foreseeable consequence, why shouldn't it be awarded? At any rate, in Ontario, so far, the law seems to be mental distress damages can be allowed in a pure breach of contract wrongful dismissal action. New Brunswick seems to have a similar principle, and in a very important case out there, the New Brunswick Electric Power Commission sued the International Brotherhood for damages arising out of illegal strike, and they collected some very large compensatory damages and $50,000 in punitive damages, and that was for the breach of a collective agreement by the union. There's been a very considerable development in the law of damages in contract generally. The test of damages is now foreseeability, and it's really the same test as in tort, with one very important distinction: that the foreseeability in contract is not like in tort, where it's a question of what would you foresee when you commit the tort. The foreseeability in contract is, as I understand the law, that's developed in the last few years, is the question of what would be foreseeable if the parties, at the moment of making the contract, had foreseen the very breach that occurred. Now, if that's the test, and I think it is, it takes little imagination to consider what the parties would have reasonably foreseen if they, at the moment that they made the contract, if they would have directed their minds to the high-handed, oppressive, arbitrary, callous, vindictive, or whatever kind of breach that in fact occurred. The parties would have said, well, sure, anybody would foresee that mental distress might occur, or that all of the elements that go up to make a punitive or aggravated damage award might well occur. So, in my view, there's no basis in theory for a refusal to grant at least the aggravated kind of damages in a contract case, and I'd go further and say the punitive type as well, if they were reasonably foreseeable given the test that I've given. Now that's a theoretical analysis. Despite what I've just said, the authorities in Ontario are very much divided on this issue, and there seems to be a move afoot by some masters and judges to keep it that way. Because there's a series of cases that go both ways on the question of whether a claim for punitive damages in a contract action should or should not be struck out. As recently as last week in the All-Canadian Weekly Summaries, I read a summary of a case decided by Master Pepiat where he struck out that portion of a statement of claim that dealt with a claim for punitive damages in a pure contract action, said it couldn't be allowed. My own view is it's hard to see how those results could obtain given the theoretical basis that I've outlined, the existence of the wrongful dismissal mental distress cases, and there are a number of cases that go the other way. Mr. Justice Southey, in a case called Jennett, which dealt with a punitive damage claim for breach of a no-fault insurance policy, refused to strike out a statement of claim for insofar as it claimed punitive damages. Mr. Justice Montgomery, in a recent case, also refused to strike out a statement of claim. He said, this was a case called Cleary versus Cabletronics. Mr. Justice Montgomery referred to a decision of Mr. Justice DuPont where he did strike out a statement of claim. Mr. Justice Montgomery, what Mr. Justice DuPont said was, I'm not convinced that the erosion, that is the erosion of the Addison gramophone principle, has gone so far as to allow damages for injury to reputation to be included in a breach of contract action. Mr. Justice Montgomery remarked as follows on this conclusion, I disagree. In my view, the erosion is such that at this state of the proceedings, the plaintiff should not be deprived of asserting its claim under this head of damage. This is just at the statement of claim stage. Mr. Justice Osler came to the same conclusion, and he said this, it has been said that in punitive damages cases, that punitive damages for breach of contract has never been granted except in exceptional cases such as breach of contract to marry. Little modern or Canadian authority has been advanced from this proposition, which is said to depend largely on Addis versus gramophone. The authority of this case has undoubtedly been departed from in recent decisions in this and other courts, as it is now entirely customary in considering the period for which compensation should be granted to take into account the fact that the dismissal itself makes it more difficult for an employee to obtain fresh employment. In my view, it is going too far to state that a trial judge might not properly award punitive damages in a case such as the one at bar should he reach certain conclusions of fact about which it would not be proper for me to speculate. And finally, Mr. Justice Linden dealt with this matter in obiter in the Brown versus Waterloo case, which in a passage that is worth quoting extensively, because if the courts do ultimately decide that punitive damages can be had in a breach of contract action, this will be the rationale. He says this, although the general principle that punitive damages are not awarded for breach of contract survives, there is no requirement that the general principle be followed invariably. Certainly in the vast majority of situations of contract breach, there would be no possible issue of punitive damages arising. However, just as our courts have recognized the utility of awards for damages for mental suffering caused by breach of contract in appropriate circumstances, the wrongful dismissal cases, so too should punitive damages be allowed where the facts demand that they be awarded. It is clear that such damages would rarely be awarded, but this does not mean it should never be done. To tie the hands of the courts by denying them the power to penalize the defendants who flout contract law in a high-handed and outrageous fashion is unwise and unnecessary. Punitive damages awards should be a part of the judicial arsenal in contract cases. That's a nice phrase, judicial arsenal in contract cases. The same way as they are in tort cases. I can see no sound reason to differentiate between them. Canadian courts, unlike English courts, have retained their broad power to award punitive damages in tort cases. Thus, if a high-handed breach of contract also happens to amount to tortious conduct, punitive damages would be awardable pursuant to the tort theory. It is said that if this conduct is purely a breach of contract and not tortious, then no punitive damages can be awarded despite the callousness of the conduct. That makes no sense. It is wrong to treat contract breach different from another merely because one violates tort principles while the other does not. In the recent years, the principles of damages in tort and contract are becoming consistent. That is good and should be encouraged. By allowing punitive damages for contract breach, that laudable trend will be advanced. Moreover, hopefully those who plan to breach contracts in a callous fashion will think twice. Now, as I say, that was arbiter because he went on to say that in the particular case it was not one for punitive damages, having given the aggravated kind of damages that he went on to give. Now, all of this discussion about the availability of punitive damages in contract cases leads into the question of whether punitive damages will or will not be allowed in insurance cases, which are, of course, merely a contract. There's no doubt that insurers in Canada are quite concerned about their potential liability for breach of their insuring agreements. I'm sure Mr. Weigel here will confirm that. He may not publicly, but he will privately. And they're concerned about the possibility that in addition to compensatory damages, that punitive damages might be awarded as well. One has to keep in mind the two very distinct situations. The first one, where an insurance carrier fails to pay a first-party claim, for instance, no-fault payments, for what you can establish are high-handed arbitrary reasons, an example being that they take the position that the amounts in question are so small that the plaintiff will never sue for them or will starve him out. He'll never bring an action. He won't find a lawyer to bring that kind of action for him. And secondly, the situation where a liability insurer fails to settle a third-party claim within the limits of the liability insurance available to it, and it was reasonable to do so. And as a result, a judgment is given against the insured for an amount over the limits. Now, two very distinct situations. And the questions arise, first of all, what is the extent of the pecuniary loss that can be awarded? And secondly, what is the extent of the punitive damages, if any? Well, clearly in the first party kind of a case, the pecuniary damages are the money that the insurer should have paid under the policy. And in the excess case, the pecuniary award is the excess judgment, the amount of the judgment and interest and, of course, costs over and above the limits of the policy. The issue is, first of all, in the case of the excess liability, can those damages be awarded and in what circumstances? And secondly, is there an award possible for aggravated or punitive damages where established where that breach was high-handed, callous, vindictive, or any one of those other outrageous things that they have to be? There's been no case in Canada decided on the issue of really on either one of these issues, except the question of the first part of insurance. There hasn't been a case where a liability insurance carrier has actually had to pay the amount of an excess judgment, with the exception perhaps of the Pelkey case, which I'll come to. No case in Canada has awarded either aggravated or punitive damages against an insurer in Canada. I told you Mr. Jefferson Southey in the Jennett case let such a claim stand, but that's a far cry from having a finding that it will that there'll be such an award. On the question of the duty of an insurer towards its insured in the excess liability case, we have one judgment, and it's a very important judgment, of Mr. Justice Katzmann in Pelkey. I won't go through the facts of that case because they're somewhat complicated, and there was no question, no issue in the case of punitive damages. But what does come through loud and clearly from Mr. Justice Katzmann's decision is that there is a good faith obligation of the insurer to settle within the limits if it's reasonable to do so. And because there was no Canadian authority on that point, Mr. Justice Katzmann thought it proper to look at what the Americans had done on that issue. And he quoted from a case called Kriski in the California Supreme Court, which put the duty this way. The implied obligation of good faith and fair dealing requires the insurer to settle in an appropriate case, although the express terms of the policy do not impose the duty. And that in determining whether to settle, the insurer must give the interests of the insured at least as much consideration as it gives to its own interests. And that when there is a great risk of recovery beyond policy limits, so that the most reasonable manner of disposing of the claim is a settlement which can be made within those limits, a consideration in good faith of the insured's interests requires the insured to settle that claim. Now, that case ought to be read by anybody doing defense work in any kind of insurance liability situation, because the duty of counsel is clearly discussed as well. The important thing for our purposes is that Mr. Justice Katzmann lay down that there is a duty of good faith which may be breached by the insurer. Now, if the duty of good faith is breached, and if it's breached in a callous and high-handed and vindictive and arbitrary way, then in theory at least there's no reason why, in addition to the compensatory award, a punitive award might not be made. A full discussion of this subject is beyond the scope of today's lecture and even the paper, although we do deal with the issue at some length and refer to a number of authorities. The Americans have been grappling with these issues for years, with, as might be expected, different results from state to state. There have been some large awards for both aggravated and punitive damages in addition to compensatory damages, and there have been, of course, a number of cases where insurers have been required to pay the full judgment over and above the limits, and a number of cases with punitive damages on top of that. There's a number of well-reasoned decisions of the appellate courts in the United States which justify these awards. In jurisdictions where the contract rule, like Addis and the gramophone, seem to bar punitive damages, the courts have developed a tort theory, and they said this breach of good faith, even though it's a breach of a contract, amounts to tortious conduct, and therefore punitive damages can be awarded. And there's a number of well-reasoned appellate decisions that do just that. My own view is that on the contract theory that I've referred to earlier, it's easy to justify compensatory damages and aggravated damages and maybe even punitive damages on the contract theory in Ontario. So we don't, in Canada, so we don't have to torture the tort theory to get to that point. Combine that with the toppling of Addis versus gramophone and the foreseeability rule, and there'll be good arguments to hold such an award on an appeal. If the conduct is sufficiently egregious, the punitive damages may well be awarded. I think a lot is going to depend on what the facts are in the first few cases that come before the courts. If the facts are weak, we're going to get some decisions that severely restrict this kind of action. If the facts are good, or if the facts are bad, maybe I should put it that way, there's really unreasonable conduct of the kind that I've outlined, we may well get a finding that will indicate that there is such liability. One of the reasons that these issues have not been very much litigated in Canada, I think, is that first of all, damages in Canada are somewhat lower, or at least have been somewhat lower historically than in the United States, and insurance limits very much higher, thereby necessitating, therefore there's very few cases, or fewer cases, in which the issue arises. In addition, I think it's fair to say that our insurers are much more responsible, generally speaking, than in the States, which may not be saying much for the American insurers. And we've never had a case yet where we've been able to demonstrate that a company will refuse to pay no-fault benefits for improper purposes. What these cases do point out is something that doesn't seem to be as well known and properly understood by solicitors as it should be, and that is the duty of a solicitor advising a defendant with an excess insurance problem. The duty of a solicitor in those cases is very clear. There must be pressure kept upon the insurer to deal with that case reasonably and to settle the case within the limits if it can be settled within the limits. And the failure to keep that pressure on, in my view, is professional negligence. And there should be threats along the way or statements along the way that the failure of the insurer to do what it has a duty to do will result or may result in a punitive damage claim being made. But as I say, my experience is that people advising insureds in those situations often don't appreciate what their duty is. Now, I want to deal finally with a number of the procedural matters, and then with the say a few things about quantum. And again, in the paper, I go into this in considerably more detail. But there are a number of important things that I want to at least deal with. Pleadings. There's a body of law that seems to indicate that the punitive damages need not be pleaded. If that's right, then we don't have to get into the decisions of Master Pepia. And but I should have mentioned earlier, there's actually a decision of the Court of Appeal on the punitive damage case that affirms Madam Justice Boland striking out of a punitive damage case, but really on a different ground. I don't think the Court of Appeal has really pronounced on that. That's a case called Cardinal Construction. I should have mentioned that earlier. But anyway, there is some argument that you don't even have to plead punitive damages. I wouldn't rely on those cases, but they're there. There's an onus on the plaintiff to establish the case for punitive or aggravated damages. The courts will not presume that just because there's been a trespass or just because there's been high-handed conduct that the aggravated damages certainly flow. You may well presume, depending on the conduct, that punitive damages will flow. Since in many of these cases the defendant won't testify, there's no substitute for careful examination for discovery and production of documents to prove the elements that are necessary. For instance, the wealth of the defendant, because that can often be an important factor on the question of quantum. In a recent case, there was a doctor that performed an operation called a remediotomy on a female plaintiff, and there was a malpractice case which wasn't defended. In other words, it was clearly lack of consent, and punitive damages were claimed as well. At trial, there was an award given for punitive damages because of what the doctor said to the plaintiff while he was doing this operation, castigating the female plaintiff for having too many children and doing a few other things. But the court disallowed punitive damages on that heading because it didn't have anything to do with a malpractice that was complained of. It wasn't sort of a separate cause of action all in its own. Criminal convictions. A criminal conviction for assault may preclude a punitive award, but should not affect a compensatory or aggravated damage award. The question of death. Where an aggrieved person has died, in some provinces, no action lies for punitive damages. In Ontario, the only restriction is that no action lies for libel and slander. There's one case in Alberta that actually held that punitive damages should never be awarded against an estate where the defendant or where the person that did the outrageous conduct died. But there were quite unusual circumstances there, but the rationale was the innocent beneficiary shouldn't suffer from for the outrageous conduct of the deceased. The question of vicarious liability is very important, and it's important for recovery purposes, but it's also important for quantum purposes, because the quantum will vary in part with the wealth of the defendant. So if the egregious conduct is done by someone relatively poor, then the damages will be commensurate with what will deter him. And the fact that his employer may be vicariously liable will make them vicariously liable, but will not affect the damages. So the approach is not only rely on vicarious liability in these cases, but do your best to identify the corporation with the actual negligence or breach on the basis of improper supervision or training or the like. Monroe versus the Toronto Sun is a good example of where this approach was successful, and the Sun itself, in addition to the reporters, were found to be liable for certain aspects of Monroe's damages. The question of insurance is important. Most liability policies don't cover liability for true punitive damages and may or may not cover liability for aggravated damages. It may well be against public policy for an insurer to provide insurance for true punitive damages. But there may be a coverage for vicarious liability, even when a punitive damages award is made against an employee, where the company itself, the insured itself, wasn't guilty of the acts. Where there's a question of the defendant's ability to pay, the action must be very carefully framed, so that you're going to get an award against someone who can pay the judgment. Joint and several liability is an important issue. In England, as laid out in Broom versus Castle, the award that can be made for punitive damages is the award that can be made against the least culpable defendant, because it's held that the liability is joint and it's not fair to burden a slightly culpable defendant with a large judgment because somebody else has been guilty of more outrageous conduct. If that's the law, then you have to be very careful who you sue, because if you sue too many people, then your award will be probably not the law in Canada. In the Vogel case, Vogel versus CBC is the best example of that issue, where there was one defendant clearly who wasn't liable for anything, and the plaintiff sought to discontinue against that defendant, no doubt being concerned about this issue. The other defendants fought like the dickens to keep that defendant in there because they wanted to rely on this principle, but the trial judge, Mr. Justice Essen, who was the same judge who tried the Robitaille case, he said the liability was several, and there could be different awards against different defendants depending upon their conduct. Interest. In Ontario, the Judicature Act precludes an award of interest being made on the punitive damage award. Contributory negligence. The Robitaille case indicates that there can be no deduction, or there should be no deduction for contributory negligence in respect of the punitive damage award, although probably there can be with the aggravated damage award, although for the Robitaille case, the $35,000 was a combination aggravated and punitive damage award, and the holding was in the Court of Appeal that there was no deduction for contribution with respect to the punitive and aggravated aspect, but there was. Robitaille was found 20% to blame for his own liability in that case. Now, there are a number of factors that go into the question of a quantum. One of the issues that will have to be resolved is whether the courts should continue to award these damages as done up to this point, simply in a lump sum basis, lumped in with the pecuniary damages, or whether they should be assessed separately. I believe that the correct position is that there should be a separate award under each head for the same reasons that have moved the courts in personal injury actions to separate pecuniary damages for non-pecuniary damages, and even to break down the pecuniary damages into the various categories of pecuniary damages. The reasoning behind that position is persuasive and I think applicable to this kind of case. The appellate courts ought to know what's been awarded as compensatory, what's being awarded as aggravated, and what's being awarded on the pure punishment basis. In the Monroe case, Mr. Justice Holland made separate awards under the headings of compensatory damages, aggravated damages, and punitive damages. He awarded $25,000 in the circumstances of that case under each heading. Mr. Justice Holland went on to apply the limits in the Linden case in the Supreme Court of Canada, the $100,000 limit. He said was applicable to a punitive damage award. Our view is that Mr. Justice Holland was quite wrong when he did that. Mr. Morris, who, as I say, wrote this paper with me, has done a case comment, which he refers to in this paper, in which he sets out in great detail why Mr. Justice Holland was wrong. But the principle of breaking down the damages is certainly an appropriate one. The courts consider a number of factors in making these awards. Clearly, the courts are saying we've got to award more than amounts to a license fee, otherwise there'll be no reason why a defendant shouldn't go on and do what he wants. Mr. Justice Montgomery, in a recent case, awarding $50,000 for punitive damages for the tort of slander of title, in addition to compensatory damages, Captain Developments versus New West, said this: New West gambled to make a profit and lost, and should bear the responsibility that goes with that type of conduct. Too light an assessment under this head of damage is but a license fee towards market savings. Too great an assessment emphasizes the penal nature of the award. I bear in mind the extensive operations of New West, their clout in the marketplace, and their ability to pay. Awards are getting higher. Mr. Justice Galligan, about a year and a half ago, awarded $35,000 against a landlord, another contract case, where the landlord, in the most high-handed manner possible, moved a tenant out of a shopping center. She said she wasn't going because she had another year to go on her lease, and he wanted that property for something else, or at least because he was going to tear the place down to build a bigger place. Just arrived at 6 o'clock in the morning one Labor Day and just shoved all the tenants' stock out on the street. Mr. Justice Galligan awarded $35,000 in addition to the compensatory damages, which were only about $5,000, for that very high-handed act.